Hi, everyone. Thanks for coming back for another video. I put up a Facebook post asking questions that people wanted to hear addressed, constitutional questions in particular that people wanted to hear addressed in light of the coronavirus slash COVID-19 outbreak and crisis. And one of the questions that seemed to generate a lot of interest was if, assuming that we ever come across a vaccine here, and that's an open question whether we will, could the government force everybody to get vaccinated? Now, to answer that question, I've asked my friend, constitutional law expert Dan Ray, to join me because we spend a lot of time talking about this stuff. Because
you're using the term expert awfully loosely.
Yeah, well,
I gotta tell you,
that's what I say when people call me that too. So, but we are nerds, right? We spend a lot of time talking about this stuff, right? To answer that question, could the government, and I guess that depends which government you're talking about, but we'll assume for purposes of this discussion we're talking about the state, right? A state government. Could a government force everybody to get vaccinated? And so the first thing I wanted to ask you to explain is the concept of state police power and how that's different from the power of the federal government, the national government.
Sure. The police power is just a fancy term that con law folks use to describe the authority of a state to regulate in the interest of public health, welfare, and safety, and maybe morals as well. We're not sure. We'll sort of set that one aside for the time being, but it's clear that the police power, as we use that term, describes a state's authority to regulate, to keep people healthy and safe, right? That is to be distinguished from the powers of the federal government. The federal government only has those powers that are specifically listed in the Constitution, generally speaking in Article 1, Section 8, plus powers that reasonably can be implied from those listed powers. To sort of shorthand it, the federal government is a government of limited, enumerated, or listed powers. The states, by contrast, are governments of much more general, overarching, unenumerated powers. Does that make sense?
Yeah. So states have a general power to protect people.
Yes, that's right.
Now there are limits on that, but. But yeah, the federal government doesn't have that power. That's why in a previous video, when people were asking about Donald Trump saying that he could open up, cancel quarantines and all that, the answer to that is no, because that's even the wrong level of government, never mind the wrong branch. Right? That's up to the states. So that's going to come into play, right? If this ever gets litigated, if people are saying the state can't force me to get vaccinated, the first thing the court's going to have to grapple with is the scope of the police power. Then the flip side of that is the strength of any individual right that might be in play, in terms of refusing unwanted, I guess what people would try to argue is refusing unwanted medical treatment. What's your view of the scope of that right, or how courts have dealt with that right so far?
Well, and you raise a critical point to understanding all of this, and that is what we're really talking about here is a balancing of interests, right? We're talking about, on the one hand, balancing the interest of the state in keeping everyone healthy and safe and alive versus the interest of each individual in being able to do what we want, to be free, if you will, from government regulation. That comes down to a good old-fashioned constitutional balancing test of one sort or another. And it's at that point, when we're trying to do that balance, that we have to define, as you say, the scope of the individual right. How far does the individual right go in protecting against these public health and welfare and safety measures? That is, I don't want to get too far ahead of us here. That's both a well-settled question and, ironically enough, in the days in which we live, it's kind of an open question as well.
Yeah, no, I guess to set up the remaining conversation, I think what people want to understand is the outcome of a case depends on what kind of test a court applies, right? And what I'm hearing you say is we don't know what kind of test a court would apply in a case like this. But you and I wrote an article together, and I don't want to get too much in the weeds, but about the difference between different types of tests that courts apply.
Yes.
If it's just
Yes.
a straight up balancing test, then I think the state's probably going to win pretty easily because, right, the interest of the state saving life probably outweighs, the interest of one individual in not being vaccinated. The question from some of the cases, we've seen courts say that we assume that there's some kind of a liberty interest, right, in refusing unwanted medical touching, but the court has never grappled with whether that's really a fundamental right, or hasn't explicitly said whether it's a fundamental right. And if it is a fundamental right, then a much tougher test, not just a balancing test, but a strict scrutiny test would apply, right? So, yeah, let's talk about in Jacobson, it was more of a balancing, right? And if you want to take us from there to strict scrutiny, what the difference would be.
Sure. Let's sort of set the table here, if you will, and refresh our recollection. We're talking about the police power, the authority of the state to regulate in the interest of public health, welfare, and safety on the one hand, versus the rights of the individual to personal freedom, right? What is the source of that personal freedom that we're speaking of? Well, there's actually more than one source, but for our purposes, the source that we're concerned with is the 14th Amendment Due Process Clause. The Due Process Clause is that part of the 14th Amendment that protects individual liberty. When you think liberty, obviously, we think freedom to do what we want. But it turns out there are different grades, if you will, of personal liberty. The lowest level is a garden variety personal liberty interest in being free to do what we want to do. But there are certain liberty interests that the courts have recognized as being very high-powered and very special. And we call those liberty interests fundamental rights. So the test that we will apply in a case like this depends on whether we're talking about a garden variety 14th Amendment liberty interest in being able to do what we want to do, or we're talking about a 14th Amendment fundamental right. Okay? Now, the court long ago, the United States Supreme Court, long time ago, settled this question in a case called Jacobson against Massachusetts, which interestingly enough involved vaccinations. It's a 1905 decision, so it's been on the books for a long time. And what the court said there was essentially this: we are talking here about garden variety police power to keep people safe and healthy and alive. Unless the individual, Mr. Jacobson, can show that he has some legitimate medical reason for not being vaccinated, and in that case, Jacobson made no attempt, really, to show that there was any medical reason that he could not be vaccinated. So for that reason, the court said, hey, the state of Massachusetts has a police power to impose a vaccination requirement. And if you, Mr. Jacobson, don't want to get vaccinated, then guess what? Pay the fine, which at the time was $5. He had to pay a $5 fine for refusing to be vaccinated. That's if what we're talking about is sort of a garden variety freedom to do what we want to do. Obviously, people who don't want to be vaccinated or don't want to be quarantined or don't want to socially distance are going to try to say, no, this isn't just an ordinary 14th Amendment liberty interest. This is a fundamental right that we're talking about. If what we're talking about is a fundamental right, and I don't know if we're going to get to that today or if we'll have to revisit it later, but if what we're talking about is a fundamental right, then the courts apply a much more stringent test called strict scrutiny. Under the strict scrutiny test, It's incumbent upon the government to prove that the government has a compelling reason, a compelling government interest for regulating this fundamental right. Now, keeping people alive, compelling government interest. Keeping people healthy and safe, compelling government interest. No question about it.
I tell students when we're talking about this in class, if you're a lawyer facing strict scrutiny and the judge is asking you for a compelling interest and you're stammering and you can't, and you're struggling for one, just blurt out, "Save the children," right? It works every time.
I used to tell students the same thing, right? We're protecting kids. Oh, what judge is going to say, "Oh, we don't care about kids, let them die"? No, any judge is going to say, well, okay, we're willing to assume for the sake of argument that that is a compelling government interest. The other thing that the government has to show under strict scrutiny is that its regulation meets a certain test that we call means testing. The government has to show that its regulation is what we call narrowly tailored. That is to say, it's necessary to impose this specific regulation in order to meet our compelling government interest. How do we do that here? Well, in the context of vaccinations, for instance, the government might create a regulation that says everybody has to be vaccinated unless someone can prove that there is a legitimate medical reason for not being vaccinated. Like, for example, you're allergic to the vaccine. You're allergic to the poultry products that most vaccines are made out of. If you can get a doctor to testify that you have an allergy to the vaccine, then the government's going to have to exempt you from the vaccination requirement, right? But as long as the government's willing to do that, then the regulation is narrowly tailored and it should pass strict scrutiny, no problem.
Yeah, that's right. I think we actually just covered a lot of territory in a good amount of space. I mean, so the bottom line is, and I think we agree on this, is look, the court might apply some kind of a balancing approach and say this is a valid police power, right, where the government's interest outweighs the individual interest. But even if it applies strict scrutiny, as long as the government carefully, right, draws up a law carefully, right, that's reasonable in exempting people who can't be vaccinated or shouldn't be vaccinated, that would probably even pass strict scrutiny if a court said that this is a fundamental liberty interest. So
exactly so.
Bottom line is the government probably wins.
The government almost certainly wins as long as courts continue to do what courts have done up to this point in time. And it's also worth mentioning, by the way, that the Jacobson case, a 1905 decision, specifically mentioned quarantines as well. The court said, what happens if somebody comes in on a boat from overseas and there's cholera on the boat? The government, under those circumstances, would be well within its authority to quarantine a person on that boat or in a quarantine center until the danger has passed. So it doesn't really matter whether we're talking about vaccines or quarantines or social distancing. These are all measures that the government is attempting to regulate in the interest of public health, welfare, and safety.
Yeah, that's fantastic. I hope that was helpful for people to understand, at least as a preliminary sort of video on this, the legal framework for how this would play out. And we look forward to doing more of these videos in the future. We're working on our technology, so we hope to improve as things go along. But this was a great discussion, and thank you very much.
Thanks, everybody. See you soon.